Good morning. you all hear us?
Yes.
All right, good morning, everyone.
Good morning.
Morning, Your Honor. Attorney McWilliams here.
Mr. McWilliams, is your prosecutor there?
Mr. DeGracia, I don't think so.
Okay, thank you. Have you spoke with him this morning?
No, I haven't, but I will.
Okay,
Thank you.
but you did check in first.
Yes, ma'am.
No, I'm just gonna go down the list. Are all parties here on Musa Al-Kafai?
I believe so, Your Honor. APA Jan Casey, I'm here on that one. I believe Mr. Kuja is on him too.
Okay, here we go.
So Al Kafaji.
Yeah.
But his image is here. He's with us in picture.
Judge, could I just have maybe 2 minutes? I'm just finishing another Zoom.
Okay, that's fine.
I'll be right back.
Who was that?
That was the defense attorney.
Oh, L. Okay. Oh, yeah, that is him. Okay.
Are all parties here on James Coleman?
Yes.
This is APA King. That is my file. I am here.
Mr. Gland on the call? You're not ready.
So you all haven't had, looks like you haven't had the calendar conference yet.
I don't see Mr. Flandy yet.
Gland is not here, so it doesn't matter.
Okay.
We're moving on.
Judge, will we be with, I'm sorry. Good morning, Judge.
Was that Brandy?
Would you be willing to waive the appearance for Brandon Harris? It's just a trial readiness.
Is Ms. McCray on the call?
Yes, she.
All right, you can go ahead and call Brandon here.
Okay. We're on the, oh, that's him. Hold on.
You don't have to call on here. I don't know why we don't.
We're on the record with the matter of People versus Brandon D.N. Harris. This is case 19-919801FH. This matter before the court is a trial readiness review hearing. Appearances, please.
Good morning, Your Honor. Andrea McCray, appearing on behalf of the people. Number 83698.
Good morning, Judge, to you and your staff. Good morning to everyone on Zoom. Justina Shabazz, P number 82743, appearing on behalf of Mr. Brandon Harris, who is not present for this proceeding, Judge. I'm asking you to waive his hearing for this proceeding.
Madam Prosecutor?
I don't have an objection.
All right, the court will waive Mr. Harris's appearance. Did we go over the trial readiness form or already? Has it been submitted?
Yes, Judge, it has. We went over it halfway. We had some outstanding discovery issues, but I believe I sent a revised checklist to your JA and sister counsel back on Wednesday. And so I think we probably should just, for the record, go through it and go ahead and submit it.
Okay, we'll do that. Somebody has some background noise that I'm getting. Whoever's on the phone, K51, you need to mute your phone. Sir, K51 with the red sweater on and you're upside down.
Yeah, my phone been messing up, Your Honor. Only one side of it work.
Okay, but you have to mute it, sir, because we can hear
I don't
your
have no
background.
music on, Your Honor. I don't have no music on.
No, mute it. You have to mute it.
Okay. Let me see if I can. Okay.
Okay, thank you. Okay, let's go over the readiness check form real quick. What I have is the prosecution has 2 witnesses. The defense has 3, 1 to 2 days for trial. No one's traveling from out of state. There's no interpreters needed. All attempts at resolution have been exhausted. Is that correct?
That's correct, Judge.
Okay. We're doing a jury trial, and all motions, including motions in limine, have been heard.
Yes.
Labs, are there any labs in this case?
Yes, Judge, they are, and they have been turned over to defense.
All right, that's right. And there was a notice of intent to use the technician's report in lieu of testimony, but then there was an objection filed by the defense. So that being the case, the witness has to be here.
Right, yeah, and I accounted for that, Judge, in my original filing, so that's the second witness.
Okay. There are no competency issues, correct, Ms. Shabazz?
None, Judge, thank you.
All right, witness list for both parties has been filed.
Yes,
What do I have here? I have
Yes,
the
Judge.
witness. Okay, let me see, make sure I have, and the jury instructions.
yes.
Okay, I see the prosecution's witness list along with the jury instructions of the charged offenses. Defense, you filed your witness list?
Judge, I originally filed a witness list when I did not know the troopers' names. However, I am going to amend that witness list now that I have learned the troopers' names. I received that, I believe it was 2 days ago, so I will update my witness list and I will e-file that.
Okay. Okay, and the felony information we have. Okay, so it looks like everything is prepared. Mr. Shabazz is, I'm sorry, Mr. Shabazz, Mr. Harris is out. So that being the case, it looks as if jury trials are going to begin in June. However, what's going to be tried first are those cases in which individuals are in custody. So it will probably be a while before this case comes up, but we will make sure that the jury trial list goes to court administration. All right, anything further from the parties?
No, Judge.
Nothing further,
Okay.
Judge, thank you.
Okay, Mr. Bass, make sure you file your witness list today.
Judge, are we gonna set another control date?
We are. I'm gonna give you a date well after jury trial should start. Maybe I'll have some information about your trial at that particular time. What is 3 months from today?
Sometime in August? Let me see, from today though.
Yes. It still be August.
August the 5th. I mean, I'm sorry, the 6th is a Friday. That's what you want, a Friday.
August the 6th.
Yes.
Okay, August the 6th at 9 a.m.
Thank you. You
That'll
all
be
take
a
care.
review date. Right, that concludes this matter.
Thank you.
Thank you, have a good day, both of you. Well,
You all
I guess
as well.
are Mr. Cray. Have a good day.
I see Brandy is here for her calendar conference. There's Mr. Kuja.
All right, Mr. Kuja, are you ready now?
Yes, ma'am, Your Honor. Thank you.
All right.
Yes, Your Honor. For the record, calling People versus Musa El Kafaji. This is case 20-389501FH. This matter before the court is a calendar conference. Appearances, please.
Good morning, Your Honor. John KCP number 56162. I'm standing in for my colleague, APA Anna Bickerstaff, on behalf of the people. Good morning.
Good morning.
Good morning, Your Honor. Jamil Kuja appearing on behalf of Musa Al-Kafaji. Should be signing on. I spoke to him just this morning. I'd asked to waive his presence if he's having some difficulty getting
He
on.
should be signing on. I just let him in.
Okay.
Can you pronounce your client's name for me, Mr. Kuja?
Yes, ma'am. Musa Al-Kafaji.
Are you on the call, Mr. Al-Kafaji?
Oh, I see him. I see his name at least.
Let me see. The court does not see him yet. Oh, I see him. He's connected. Mr. Al-Kafaji?
Yes, ma'am.
Okay, good morning to you.
Good morning.
Your case has just been called. I need you to turn your camera on, please.
Yes, ma'am.
Did we lose him?
Let me see. Mr. Al-Kafaji, state your name for the record. Looks like he's off. Okay, well, let me ask this, is there an offer that's being made to the defendant?
Yeah, there has been an offer tendered. Unfortunately, I don't have the file with me. Mr. Kuja and I spoke this morning about the case. Perhaps he can put the offer on the record. I think,
So,
It's not an
Hold on
offer
one-
he wants to accept, Judge.
yeah.
I was going to try to.
we need him back then, we need him back, and he's off the call now.
Okay, we were just going to ask to set either another pretrial or, go ahead and set dates for a final conference. I'll try to keep
Okay,
negotiating with Mr. Casey.
okay.
Usually
We'll do that.
reasonable.
All right, do you have to order a reciprocal discovery?
Oh, no, I'm just wondering.
Okay, the motions, was there was the exam held in this matter?
No, it was not.
All right, so let's wait. So are there any motions anticipated on either side?
Not on behalf of the people.
No, I don't think so, Your Honor.
Okay, he's trying to get back in now. Hold on a second. Okay, well then, what I'll just tell you is the motions, if there are any, shall be time-stamped and filed no later than June 18th. Any responses will be due on June the 25th. There will be a final conference on July 2nd, 2021. Mr. Al-Kafaji, can you state your name for the record for me, please?
Musa Al-Kafaji.
Okay, all right, we know we lost you for a second. The only
I'm
thing
sorry,
we're
my
doing
phone.
is getting- That's okay. The only thing we're doing is getting dates, because your attorney has indicated he's still in negotiations with respect to your case. Okay,
Okay.
all right, so, final conference will be July the 2nd. If there is a resolution prior to that date, please contact the court and we can put you on the docket. Other than that, I am signing the calendar conference, the date, as well as the order of reciprocal discovery, which will be sent to the parties. Are there any other matters?
Not on behalf of the people, no.
Nothing for me either, Your Honor. Thank you.
Okay, both of you have a good day. Mr. Al-Kafaji, have a good day as well.
You too, ma'am. Thank you.
You as well, Judge.
You're welcome.
Bye.
Bye-bye.
Your, I'm also here on, I believe Mr. Al-Kafaji has a co-defendant, Mr. Al Hassoun. I'm here on that as well. I'll just hang out in the waiting room.
Do you know who his attorney is?
I'm not 100% sure. It might be Amir McLeod, I think.
Yes, that's what's listed on the
Yep.
file. Looks like this. Okay, all right. Ms. Robinson, good morning.
Good morning, Judge. How are you?
I'm well. What do you have?
I am here on Gary Riggs. We have a calendar conference and Mr. Riggs is present, as is APA McCray.
Okay,
Is that your APA judge?
yes.
Okay, I gotta get their name for the record. I guess I'll get it when I call it. All right, for the record, calling People versus Gary Riggs. This is case 21-214501FH. This is the date, time scheduled for calendar conference. Appearances, please.
Good morning, Your Honor. Andrea McCray, appearing on behalf of the people, P number 83698.
And Brandy Robinson of the Neighborhood Defender Service. My P number is 66895. I'm here on behalf of Gary Riggs, who is participating by Zoom.
Mr. Riggs, are you here?
Yes, ma'am.
Okay, Mr. Riggs, good morning.
Good morning.
State your name for the record for me.
Gary Riggs.
Okay, do we have an offer from the people?
Judge, so I don't have my file with me. I believe it's with the gun board committee, because Ms. Robinson indicated to me that she had submitted a gun board. So I don't have an offer at this time, but we are waiting to hear back from the gun board.
Okay, all right, Ms. Robinson, when did you submit the gun board letter?
It was sometime last month, Judge. I have to double check.
Last month, and we still don't have a. See?
Judge, yeah, it's taking about that. That's not uncommon. They have so many requests right now that it is taking a little bit of time.
I agree with that, Judge. It's just lengthier than it has been because there's so many CCW cases and gun cases in the system.
Okay, I'm gonna give you the dates, but I'm also gonna give you a pre-trial so we can see if any decision has been made prior to the final conference. Was the exam held?
It was
No,
waived.
Okay, did either side anticipate filing any motions?
No.
No, Judge.
Okay. All right. If there are any motions, they will be time-stamped and filed no later than June 18th. Any responses will be June 25th. The final conference will be July 2nd at 9 o'clock. But I'm going to give you another date to see if we have a decision by the gun board. And that date will be, today is May 7th. How many matters do we have on May 28th?
Judge, for what it's worth, I expect to be out of the office on the 28th of May.
Okay. What about June 2nd?
You got 27 matters on that day,
On what day?
June 2nd,
Oh my goodness, we're gonna have to change that. How many matters do we have on June 4th?
18.
Okay, June 4th.
Very well.
June 4th at 9 o'clock, and at that time, pre-trial, we'll see if we have a decision at that time, and if we can have a resolution. The court has signed the order of reciprocal discovery, as well as the scheduled conference date that will be sent to you by the clerk. Anything further?
No, Judge. Thank you.
You're welcome. This matter is concluded. Mr. Riggs, have a good day.
All right. And you too. Have a good day.
All right. Are all the parties here on Royce Houston? Are all the parties here on Decalvin Johnson?
I'm here, but
D'Angelo Miller?
I'm here.
Probation is here.
Okay, is Mr. Miller on the line? Okay. Osborne, are all the parties here on Osborne?
Do we have an order for him?
Oh,
Osborne, he's the version, the version.
review date?
Yeah.
I don't know. You don't have it up there.
I don't have the order. I just have the one placing them on the version. I don't have the order. Just missing it. I don't know where it stands.
It doesn't look like anybody. Ms. McCray, do you have the order regarding Mr. Osborne? It's missing him from diversion, if everything has been done as it was supposed to be?
I do not, but I'm gonna text Mr. Heaphy right now.
Okay.
Can I have Ms. McCray's P number, please?
83698.
Thank you.
No problem.
All right, who has a matter that all parties are ready?
Your Honor, we're ready on the Sills matter. Mr. Sills is on the call. It's been trial ready since before Your Honor took the bench.
Okay.
We're ready on Coleman, Judge. James
I'm
Coleman.
sorry.
I'm calling Seals. I'll call.
Okay, we'll call Seals first. Okay, go ahead.
All right, this is the matter of People versus Darnell Seals, case 20-153001FH. This is a trial readiness pre-trial review.
Good morning, Your Honor. Andrea McCray appearing on behalf of 83698.
May it please the court, Neighborhood Defender Service of Detroit by Jeffrey Konecki on behalf of Mr. Sills, P64800.
All right, good morning to everyone. Is Mr. Seals on the call?
He is. Mr. Sills, can you state your name for the record?
Yes, ma'am. Darnell Seals. Hey, Your Honor.
I'm well. How are you, Mr. Seals?
I'm fine. Getting ready to go to work.
Well, good. I'm glad.
Yes,
Now,
ma'am.
We have a trial readiness form. I understand that this was submitted prior to my, taking over the docket. Was this gone over on the record, Mr. Konecki?
I recall, yes, we went over and ensured that everything was checked off and that everything had been completed. I want to say it was either late October or sometime in November. And then we've had some pre-trials, and then we've had some, because there's an open probation case, some other court dates that have been associated with Mr. Sills.
All right, the probation case is just tracking?
Yes, Judge.
Yes.
Okay, well, as I indicated to the previous party, jury trials are slated to start in June, especially since the numbers are going down. I do believe that they will begin. However, as I indicated to the other party, the priority are those individuals that have been in custody all this time. So what I will do, just to make sure the case does not fall through the cracks, is I'm gonna give you a date well after jury trials start, so I can find out if there's any movement on this. So give me a date in August.
You don't want that same date in August, or
Yeah, you can give me that same date.
August 6th?
August 6th at 9 a.m.
For just kind of a pre-trial, Your Honor?
Yes, just a review date, that's it. You know, if it gets scheduled before that time, the court will alert you, but I doubt very seriously that this one would get scheduled when you've got so many people that are still in custody that's been sitting there since 2019. Okay?
And Your Honor, and then if, after the pretrial part of it, I did want to address the issue of regarding hours on tether for Mr. Sills.
Okay, let me see the file again. All right, what is the issue?
Your Honor, we were before Judge Hood. There was a tether issue, and he appeared before Judge Hood, and Judge Hood agreed to reinstate him on tether, but would only do house arrest before Your Honor was able to hear the matter. Mr. Sills is working. He does work some kind of different hours. He can give you a better idea of how his schedule changes. But we're asking if the court would allow him hours to attend work and be able to handle those kind of things.
How is he attending work now?
He actually hasn't been since, my understanding, he's only gotten out in the last, I would say, few days, week at most. He was in and then had to get refitted with his tether, and that took some time. So I know that he has, since we were in front of Judge Hood, which I want to say was last month.
It was April 22nd.
March 16th.
April 22nd.
And then we had
Clerk is showing April 22nd.
that's yes.
Oh, yeah.
After April 22nd, then I know as of checking as much as late last week, Mr. Sills was still in, and then I got an email from his fiance that he was out, and then they were requesting the Zoom information for today. So I knew he'd finally made it out. So he hasn't been going to work or doing anything. He's been staying at home now, and that's why we're trying to address the issue, because we know that there's at least, before the court again, at least about 3-month period, and potentially longer before this case goes to trial, and he would like to get back to work.
Mr. Seals, what do you do for a living?
I do like landscaping and I do all types of stuff. I fix on houses. Like I got a house I'm gonna go fix on right now. We do drywalls, landscaping, really anything, just so I can pay my rent and keep my kids with a roof over their head.
Okay, Madam Prosecutor?
Judge, you know, I would prefer that he has documentation to show where he's going to work. I don't know if that's going to be possible with what he just said, as he has different landscaping jobs, but if there's a company that could provide documentation, I am concerned. I spoke to the Ms. Schoen last night and the night before about his new criminal activity, and perhaps Ms. Schoen can provide the court with some further details on that, but they're pretty serious allegations of domestic violence and allegedly choking a female to almost being unconscious. So I do have some concern. He's on probation for weapons, firearms offenses. This new case deals with firearms. And then the pending criminal activity or arrests is a little concerning, I would say, to the people.
Ms. Shaw.
Yes,
What is the new criminal activity?
Well, he was arrested and charged with 2 counts of assault. However, they chose not to prosecute in both cases.
Ms. Shaw, I can't understand you. You're going in and out.
Can you hear me now?
Yes, that's better.
Okay.
Go.
There were 2 separate allegations of assault with 2 separate females, 2 days apart. However, they chose not to prosecute.
Okay. Well,
Hey, Your Honor.
yes, Mr. Seals.
Yes, with that situations, both of them, I can contact my probation officer. Both of them is like they was making up lies on me to try to get me locked up.
Mr. Sills, don't discuss the details of that or any investigation or arrest.
Okay.
The judge understands that they have not gone forward with those matters.
Okay,
sir. All right. Well, that being the case, then the court will remove the tether. However, Mr. Seals, I do not want to receive any new criminal activity. Understand?
Yes, ma'am.
Because the next time you may find yourself actually incarcerated. So since we have a situation where we actually don't have any pending charges at this point, based on Ms. Schoen has indicated to the court, these individuals have not decided not to pursue this, I'm going to remove your tether.
Okay, ma'am.
Judge,
yes, ma'am.
The people would strongly object to the removal of the tether. Brother counsel was just asking that the hours be modified so he could go to work. I think he still should have a tether on.
Well, my understanding is the current offense is not assaultive. It's a gun case, right?
Correct, Your Honor.
All right. So that being the case, the court is going to remove the tether. Mr. Seals?
Yes.
How old are you?
I'm 24.
All right. This is your warning, Mr. Seals. If I get any new criminal activity, it's going to be more than a tether. You understand?
Yes, ma'am.
Okay. All right.
Thank you, Your Honor.
Yes. You're welcome. All right.
Did we say Coleman or?
It's Mr. Glander's case.
Okay. Ready, Mr. Glander? Parties on Coleman?
Yes, good morning. This is APA King for the people, P78774.
She hasn't called the case yet, and it doesn't look like Mr. Glander is ready.
All righty.
Because I believe we were ready on Jerome Fitzpatrick. I know the prosecutor is here, but I'm not certain if my client is in the waiting room.
There isn't anyone in the waiting room at this time.
Oh, all right. Thank you, Judge. Let me call him.
You're welcome.
Is there a diversion review on Osborne this morning?
It's scheduled.
That's what we're looking for, but we don't have an order. Ms. McCray was going to contact Mr. Heaphy.
Judge, Mr. Heaphy is checking on whether the restitution was paid in this matter, and so he asked for a few moments to, make sure the documentation is there.
Okay, so we have to wait and see if we have the order. We don't have it at this point in time.
All right, thank you,
Williams?
Judge.
I saw DeGrazia,
Here's Mr. McWilliams right there.
but DeGrazia was the prosecutor. I did see him.
I believe we're waiting for Miss
Mr. DeGrasse.
Walker to come on.
Oh,
I'm here, Judge. This is Dominic DeGrazia.
Yeah, he's here. So we're ready.
ready?
Mhm.
They're setting up the equipment for Miss Walker.
Oh,
Oh, is that the defendant?
yes.
Okay. All right. Who is ready with all parties?
Your Honor, this is Henry Schneider with NDS. I'm here for the Tyrone Douglas violation of probation hearing. And I wanted to let the court know that my client's in federal custody now, and that's why I haven't been able to get a hold of him.
Okay, well, might as well call that one.
All right. All right, for the record, calling People versus Tyrone Douglas. This is case 18-5543. This matter before the court. Has it been arraigned yet?
I don't know.
Michelle, it's an arraignment on a warrant for violation of probation.
Appearances.
Good morning, Lori Schoen, Department of Corrections.
Good morning, NDS Detroit by Henry Schneider, 82476 for Mr. Tyrone Douglas, who is not present.
Ms. Sean, was this arraigned?
Yes, yes, he's been arraigned and we're just tracking.
Federal case? We're tracking the federal case?
No,
Ms. Sean, I can't understand you.
that was a weapons charge.
You're going in and out.
I'm sorry. The weapons charges from 36 were dismissed and picked up by ATF.
Okay. All right. So we're just tracking.
Yes.
All right. So do we have a date for what's happening in the federal court?
He's being arraigned today.
All right. So let's get a date after, I have no clue. All right, let's do,
Oh, no.
I'm about to take it into June anyway.
Right, the next Friday, you got 24.
Yeah, I'm not doing any more. I'm not doing any more May dates.
Okay.
June 16th.
Thank you.
Thank you, Your Honor.
You're welcome.
All parties are ready on Walker.
Okay.
We're ready on Coleman.
Okay. All right, there you
Which
go.
one, Judge?
Doesn't matter.
Okay. I'm gonna probably be quicker.
Okay.
All right. I'm gonna call it and I'll give you the file.
Okay.
For the record, calling People versus James Van Coleman. This is case 21-1249. Matter before the court is a pretrial. Appearances, please.
Good morning, APA Larry King for the people, P78774.
Good morning, Judge. Richard Glanda for Mr. Coleman, 32990. I believe he's on the call, ma'am.
Morning to all of you. Mr. Coleman, are you on the call?
Yes, ma'am.
All right, please state your name for the record.
James Coleman.
All right. Is there an offer from the people on this?
Yes, Your Honor, there is an offer from the people. It would be to plea to count one of the amended information, resisting, assaulting, obstructing a police officer, dismiss the domestic violence charge, and there's an agreement to a 2-year probationary sentence. That offer has been reduced to writing and sent to Mr. Glanda.
Judge, that's correct. And I forwarded it back to either the prosecutor or to the court. The court or the prosecutor should have an executed copy of that plea form that I dated 4/23/21, signing Mr. Coleman's name with consent.
I do not have an executed copy of that.
And neither does the court. And also, I don't have an amended information either. Is there an amended information on Odyssey that was filed?
Judge,
Was that
I
amended
can,
information filed with the court?
Let me look into that right now.
Judge, I'd be able to email a copy of this plea form to the court, but I can't do it currently. If we could take the proofs and then I can do it later this morning, if that's sufficient.
No, the court cannot take pleas without having the plea form signed in front of it. So what we can do is pass this matter and call it later on this morning. Or get a new date.
What email can I send it to, Judge?
Send it to me.
Yeah.
Send it to me, Mr. Glanda.
And what is
You have
that?
Send it to Crystal. Do you have my email address?
No, I do not.
Crystal.bright, that's B as in boy, .bright at thirdcc.org.
Crystal, CRYSTAL B
Yes.
dot Bright.
No, Crystal.bright
Okay.
at thirdcc.org.
It's first
All right.
name, that last name.
Okay. Crystal.bright at 3rdcc.org.
Yes.
Correct. And we need an
All right.
admitted information.
Yeah, it has been.
I'm working on it.
All right, Judge, if
All
we
right,
could pass this matter and,
We are gonna pass this matter.
all right, thank you.
Okay, who else is ready?
Walker matter, Your Honor.
Okay.
All right, we're on the record with the matter of People versus Susan Ray Walker. This is case 19-287701FC. This matter before the court is a pretrial. Appearances, please.
Dominic DeGrazia on behalf of the people.
John McWilliams for Miss Walker, P17565. I see that Miss Walker is on. The caption is Genesis House number 3, where she's been housed for the last 4 weeks.
Okay, good morning, everyone. Ms. Walker, state your name for the record.
Susan Walker.
All right, good morning, Ms. Walker.
Good morning.
How are you doing?
I'm good. How are you?
I'm well. Okay, the court is in receipt of a settlement offer, advice of rights, notice of acceptance. So it appears that the parties have come to a plea on this matter. Mr. DeGrazia, would you put the terms on the record?
Yes, Your Honor. The defendant is going to plead no contest to count 1, a reduced count 1 of second-degree murder, as well as count 2 felony firearm. There is a sentence agreement on the second-degree murder count of 10 to 20 years in the Michigan Department of Corrections. And that sentence will be served consecutive to her sentence on count 2 for felony firearm, which is a 2-year sentence in the Michigan Department of Corrections.
Okay. Is that your understanding of the plea offer?
Yes, Your Honor.
Likewise, Your Honor.
Okay. And Ms. Walker, you had an opportunity to discuss this plea offer with your attorney?
Yes, I did.
I saw the person last Saturday, Your Honor, at Genesis House.
Okay. Ms. Walker, raise your right hand. Do you swear? Oh, go ahead.
You solemnly swear or affirm that your testimony in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, Ms. Walker, how old are you?
45.
How far did you go in school?
My GED.
You received your GED. Okay. Can you read and write the English language?
Yes, I can.
Do you understand what's happening here today?
Yes, I do.
All right, and I am in receipt of a settlement offer, advice of rights, notice of acceptance in which there is a charge reduction to homicide second degree, which is a life offense, as well as weapons felony firearm, which is a 2-year offense. There's a sentence agreement in which the people on count 1, 10 to 20 years, Michigan Department of Corrections, to be served consecutive to count 2, which is the 2 years in Michigan Department of Corrections. And that is your understanding of the plea agreement?
Yes.
Are you satisfied with your attorney's representation?
Yes.
All right. And you understand that the original charges on this matter. Hold on one second.
She was originally charged with felony murder, Judge.
Okay, I have it now. Homicide, felony murder was count 1 and count 2 was felony firearm. You understand those were the original charges, correct?
Yes.
All right, you understand that by pleading guilty here, you give up some rights that were listed on your form. And you went over those rights with your attorney?
Yes, I did.
All right, the court is gonna briefly go over those. By pleading guilty, you give up the right to a trial by jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial. This plea form is, to have, yeah, to have any witnesses against you be questioned by your attorney, to have the court order any witnesses that you have to appear at trial, to remain silent during the trial, to not have that silence used against you, and to testify in the trial if you so chose. You understand you give up all those rights?
Yes.
If your plea is accepted, you give up the claim that the plea was the result of any promises or threats that were not disclosed to the court at the time of the plea proceeding, or that it was not your own choice to enter into a plea. You understand you give up that right?
Yes.
And if your plea is accepted, you may be giving up rights to, and I should say your NOLO plea, to appeal issues that would otherwise be appealable if you were convicted at trial. And any appeal from your plea and conviction will be by leave as opposed to by right. So what that means is, if you want the Michigan Court of Appeals to look at the circumstances surrounding your plea and sentence, you would have to ask them to do that, and it is their choice whether they choose to. If you had gone to trial and were found guilty, it is an automatic right. They automatically look at the case. So you understand you're giving up that automatic right of review?
Yes.
All right, knowing and understanding all the rights we just went over, is it your wish to give up those rights and plead guilty today? I'm sorry, to enter a NOLO plea today?
Yes.
And other than the plea agreement, has anyone promised you anything to get you to enter into a NOLO plea today?
No.
Has anyone threatened you or coerced you in order to get you to enter a NOLO plea?
No.
All right, and you're in fact pleading NOLO, no contest of your own free will?
Yes.
And are you currently on probation or parole to this court or any other court?
No.
All right, Mr. Prosecutor, what are you gonna do to establish the facts of this plea?
Your Honor, I'll read from the investigator's report.
Okay, go ahead.
Judge, the investigator's report reads that on December 10th, 2018, at 19922 Chapel in the city of Detroit, County of Wayne, state of Michigan, Detroit police officers arrived at that address approximately 11:34 p.m. When they arrived, they found a deceased individual by the name of Lloyd Butts, who was already deceased at the scene. Mr. Butts was later examined by Dr. Lockman Sung of the Wayne County Medical Examiner's Office, who determined that Mr. Butts' death was the cause of multiple gunshot wounds and that the manner of death was homicide. Furthermore, on approximately January 18th or 19th of 2019, Mrs. Walker was interviewed by the Detroit Police Department. Over the course of that interview, she told police that she participated in what she believed was going to be a robbery for some pills. She said she participated in this robbery with Mr. Jack Beach and 2 other individuals, one by the name of Ant. She told police that she believed that it was Mr. Beach's role to rob the complainant of pills. It was her role to drive to the location using her car and drive away from the location. She told the police that when they arrived, the individual known as Ant and the other unknown individual jumped out of the car and shot Mr. Butts with a Draco-style handgun. That after they shot Mr. Butts, they got back into the car, and Miss Walker drove them to a hotel where they ultimately were given money for gas. So with that, Your Honor, I believe that is a sufficient factual basis.
Agreed.
All right. Okay, has the court complied with Court Rule 6.302?
Yes.
Yes.
Okay, the defendant will be referred to probation for a pre-sentence report. And, Ms. Shawn, will probation contact Genesis House, or does Ms. Walker need to contact probation still?
As long as Genesis House is on the referral, we'll contact her.
Very good.
Put it on the referral.
Okay, the clerk is gonna put, Genesis House on the referral.
Thank you.
So you should get a call from probation, Ms. Walker, at which time you will be interviewed for your sentence. Sentencing date will be?
Ms. Shawn, should I give her an in custody date like May 28th?
Well, you know, no.
No.
No, she's not in custody.
No, she's not.
Okay. All right, so, how about, June, hold on. What was that? June 11th? Friday,
That'd be
June
great.
I'm looking at my calendar.
Okay, so your
Time, Your Honor.
sentence will be Friday, June 11th. Now, there's another issue. I know that, there's a co-defendant on this case, which Mr. Cripps, I believe, is the defense attorney for that case. And they're scheduled to be back in court on, I believe it's the 13th.
That's correct, Your Honor.
Okay, so I believe that the parties probably need to come back on that date.
Judge, if I
Yes.
may. So I did have a chance to call Mr. Cripps prior to the plea and let him know what was going on. And it does look like he's logging on, although his audio doesn't seem to be connected yet. But my concern is, given what I believe to be the motive for this homicide as admitted by Mr. Beach, I do not feel comfortable with Mr. Beach knowing where Ms. Walker is staying right now. So
thank you.
I can see that she's identified on the Zoom where she's staying. So I don't have a problem with them both being set on the same date, but I'd prefer if Mr. Beach was not logged into the Zoom while Ms. Walker is on the Zoom.
Your Honor, if there were circumstances such as that, which would not require Ms. Walker to be present, we would so move. She does have a date for sentencing.
Well, that's true. Let me, Mr. Cripps, it looks like looks like he's having problems logging in. Because I do understand what Mr. DeGrazia is saying, and the court does agree that it does not want Mr. Beach to know where Ms. Walker is. So why don't we, well, let me ask this, really, is it really even necessary for Ms. Walker to be on the call if Ms. Walker's attorney is on the call?
I don't believe it is, Your Honor.
I'll be happy
I
to do that.
don't believe it is. Any issues, her attorney can handle. So that being the case, I believe it is scheduled for May 13th. I am not requiring Ms. Walker to be on the call, just that Mr. McWilliams be on the call.
Thank you.
Okay.
Mr. DeGrazia, can you send me the investigator's report, please?
I can. It may be like tomorrow or Monday, but I will get it to you.
I'll just send it to, send them the copy of the information.
Okay, you don't have any way of emailing that, Mr. DeGrazia?
Unfortunately, on my setup here, I only have the report for her co-defendant. I don't have her personal investigator's report, so I'm gonna have to go to the office to get that.
Okay. The report for the co-defendant is not the same?
I mean, it's the same. It just doesn't have her name on it. If that doesn't matter, I can send you a report.
We can always just, white out the name and put her name on it. It's the same report.
Right, Mr. DeGrazia, can you just put her name on it?
Yep. And what email address would you like it sent to?
The
Crystal,
CRYSTAL .BRIGHT@thirdcc.org.
Okay.
And actually, you can just add her name and add, you know, her case number,
Hey,
which
what's
she's
up?
for 02.
Right.
Yeah,
Still,
you can
huh?
just, yeah, but it'll have it different. I don't know if in case it has the case number on it, she would be 02. The co-defendant would be 01. So if the case number is on there, just make her 02, so we'll know it's just for both.
Will do,
And
Your
that
Honor.
solves that problem. Okay. All right. Anything further from the parties?
Just a thank you, Your Honor, to you and your staff for the courtesy shown.
No problem. All right, Ms. Walker. We'll see you June. What day was that?
I'm sorry, that was June 11th.
June 11th.
Okay, thank you, Your
All
Honor.
right. Have a good day.
You too.
And I don't have that free yet either. There's Mr. Cruz. He said, I don't have that free yet. Random.
Oh, Glenn.
And Mr. Cruz is on, he's on something, he's got a sent.
Wasn't there something else ready to go?
Yes,
Your Honor, I'm ready on Tremonte Dan. He's in the
Judge,
waiting.
oops, I'm sorry. I'm ready on Devacon Johnson too.
Johnson?
Your Honor.
Okay, let's do Johnson.
And Your Honor, David Cripps, I'm ready on the sentencing for Martin Stewart.
Okay, so that's Johnson, Stewart, and who was the third one?
Man, it's the final conference, here's Johnson.
Okay.
I'll call the case first.
Yeah.
Calling people versus, is that Decovin Johnson? DeCoven?
DeCoven Johnson.
DeCoven Johnson. This is case 20-296201FH. This matter before the court is a continued calendar conference. Appearances, please.
Good morning, Your Honor. Andrea McCray appearing on behalf of the people, P number 83698.
Good morning, Judge. Melita Baird on behalf of Devacon Johnson, P43238. Judge, there was an offer made to Mr. Johnson and he wants to proceed to jury trial.
Okay, Mr. Johnson, please state your name for the record.
DeCoven Anton Johnson.
All right, good morning, Mr. Johnson.
Good morning, everybody.
Madam Prosecutor, can you state what the offer is?
Yes, Judge. So the offer would be to plead guilty to the reduced count of attempts, count 1. That is assault with a dangerous weapon or felonious assault. The attempt makes it a 2-year maximum felony. We would dismiss count 2, domestic violence, and the second offense notice on the count 2 domestic violence. We would also withdraw the habitual 4th offense notice. It would be a sentence agreement of 2 years probation with the first 6 months in the Wayne County Jail, anger management, and no contact with the victims. In this case, Martin Lundy and Tiani Bigham. That would be the sentence or the plea offer from the people.
Okay, and Madam Prosecutor, if Mr. Johnson goes to trial and is not successful, what are his guidelines?
His guidelines as charged, Your Honor, are 10 to 46 months, and that's the minimum. We would be asking for a higher prison time than that.
All right, so that's 10 months to 46 months on the low end. What's the tail?
The tail is going to be 15 years.
All right, so just so that the defendant is aware, Mr. Johnson or Ms. Baird, you understand that you heard the people's offer. If you go to trial and not successful, the people could possibly be asking for 46 months, which is close to 4 years to 15 years. You understand that, Mr. Johnson?
I don't understand it, but I didn't hit no lady though.
Okay, well, Miss Baird, do you want to break our room with your client to make sure he understands it?
I can go in the breakout room or I can call him. Do you want to talk to me anymore, Mr. Johnson?
Yes, Ms. Baird.
Okay, well, yes, you can put us in the breakout room, Judge. Thank you.
Judge, do we want to adjourn this? I feel like I almost feel a little uncomfortable. I want to make sure he has plenty of time to really fully understand, the amount of prison
mean-
time at stake.
I did 4 years in prison.
One second. I'm gonna let the defense attorney indicate what she wants to do at this point in time, so.
Well, Judge, you know what? I did go over this, but since he says he doesn't understand, I would say that I would agree with the prosecutor just to make sure before he takes or doesn't take it. If we could adjourn it, I think that may be a good idea, rather than spend 3 minutes in a breakout room.
Yeah, I like that too.
Okay.
We'll give it to you. Let's go into June.
But I didn't even touch.
Hold on, Mr. Johnson. Mr. Johnson, don't talk about the facts.
There's
Just
no
hold on.
need to speak. You'll be able to talk to your attorney later on. You won't be back here until June.
Is Wednesday one of your days, Judge? or
Yes,
Monday?
Wednesday and Friday.
Okay, because the 9th is pretty clear.
It's clear because my investigator is on the 9th.
Oh.
And it's gonna be completely clear in a minute.
Okay. So let's move forward here. You said, well, the 18th is good.
Okay. June
18th?
18th.
That sounds good. Thank you.
So when we come back on June 18th, we will know whether we have resolved this matter or Mr. Johnson is gonna proceed to a jury trial. Okay?
All right.
Retrial
Thank you.
June 18th at 9 a.m.
All right. You all have a good weekend. Thank you.
You too. Mr.
Thanks.
Johnson, have a good day.
You too.
Next.
Next is Van, Mr. Harris. Okay. All right, Mr. Harris, parties on Van, are you ready?
Yes.
Yes.
All right, for the record, calling People versus Tremonte Van. This is case 21-815-01FH, and this matter is a final conference. Appearances, please.
Good morning, Your Honor. Andrea McCray appearing on behalf of the people, P number 83698.
Mr. Harris, you're muted.
Yes, Your Honor. I'm Wyatt Harris, P54891, on behalf of Mr. Tremonte Van, who appears via Zoom.
Good morning, Mr. Harris.
Good morning, Your Honor.
All right, Mr. Van, state your name for the record.
My name is Tremonte Van.
Okay, is there an offer from the people?
No, Judge, we are, again, this is a gun board submission. We're waiting to hear back from the gun board.
Okay, Mr. Harris, when did you submit your gun board letter?
I submitted it yesterday. We finally got all the documentation that we needed, Your Honor.
Okay, yesterday. Okay, so that being the case, I'm gonna give you a little while. I think
Okay.
the gun board is overwhelmed, so it's taking them a little longer. June. How many do we have on June 11th?
5 right now.
June 11th,
That works, Your Honor. 9 o'clock.
9 o'clock.
Okay.
Everybody back on June 11th.
Is that a pretrial, Judge, or a final conference?
No, it's a pretrial.
Okay.
Have a good day, Your Honor. Be safe, staff.
So June 11th, 9 a.m.
Yes.
Yeah, that's correct.
Okay.
All right, Stewart.
Okay, got it. Parties on Stewart, ready?
Ready, Your Honor.
For the record, calling People versus Martin Paul Stewart. This is case 19-59801FH. This is the date and time scheduled for sentencing. Appearances, please.
Who's the prosecutor?
Good morning, Your Honor. David Cripps, P34972, on behalf of Martin Paul Stewart.
Mr. Cripps, who's the prosecutor?
Miss Tara Mathena was the prosecutor at the time of the guilty plea.
Okay, we need to get Tara Mathena on the call then. Ms. McCray,
Yes, Judge.
do you have a number for Ms. Mathena?
Yeah, I believe so. I'll email her or text her.
Okay, all right, we'll have to pass this until we can get the prosecutor. Next.
Mr. Bernie, are you ready?
I'm ready.
Hold on a second, let me, know it's right with H. All right, so that's, parties on Hurston.
That's correct.
Okay, is everybody here on Hurston?
Yes, Your Honor.
Yes, Your Honor.
The record, calling People versus Royce Hurston. This is case 20-5229-01FH. This matter before the court is a pretrial. Appearances, please.
Good morning, Your Honor. Andrea McCray appearing on behalf of the people, P number 83698.
May it please the court, Jerome Barney, P 28321, appearing on behalf and with the defendant Royce Houston, who is present.
Good morning, Mr. Bernie. Mr. Bernie, your phone is going in and out a little bit.
Actually, I'm on a computer.
Oh, okay, I can hear you better now. Maybe you were just too far away. Mr. Hurston, state your name for the record.
Royce Hurston. How you doing, Your Honor?
I'm well. Good morning, Mr. Hurston.
Good morning.
All righty. Last time we were here, there was an offer put on the record. Is the offer still the same, Madam Prosecutor?
I'm not sure, Judge. The gun board did grant a reduction. I don't know if you have that new offer, so just in case, I'll put that on the record. So the offer is to plead guilty to count 2, which is controlled substance possession less than 25 grams. That is a 4-year maximum felony. It would also be a plea to attempt. So the reduced attempt to count 4, which is weapons carrying concealed. That attempt makes it a 2.5-year maximum felony. The sentence agreement would be 2 years probation with the first 60 days in the Wayne County Jail. Just to be clear, we would dismiss count 1 and we would dismiss count 3, the weapons felony firearm count that requires the mandatory consecutive 2 years.
Yep, that's the offer the court has.
Oh, great.
So, Ms. Barney, what is your client doing?
We're accepting the offer, Your Honor.
Okay, is there a plea agreement that has been executed?
Not at this point.
That's what we have to have in order to take it. So,
Well, if the Ms. McCray would.
So I sent it to you on April 14th, 2021, the plea form.
April 14th,
Yes, sir.
2000 what?
21.
okay, well,
I
Mr.
don't
Barney,
have it in. I don't have it in my possession. I need some time to download it. My client.
we can't hear you, Mr. Barney. Do you indicate that you need her to send it to you again?
Yes, please.
Okay, 1 second. Let me go.
Okay, she'll do that. When you receive it, Mr. Barney, you're gonna have to go over it with your client. You can put your phone on mute and call your client. Once that's ready, then we can come call this matter again, okay?
Okay, I just sent it.
Your Honor, is there on an adjourned date?
You want a different date?
Yes.
That's fine, we can do that too. We're going into June. What was that, June 11th? that I just came before? June 11th, 9 o'clock.
You're on the June 11th.
And just to be clear, Judge, I'll keep the offer open until June 12th.
I'm available on June 11th at 9 o'clock.
All right, Mr. Hurston, your next date is June 11th at 9 o'clock, okay?
Yes, ma'am.
All right, I'll download that and we'll give Mr. Hurst forthwith, Your Honor. Thank you.
All right, the offer is open until June 12th per Madam Prosecutor. All right, that matter is concluded.
Thank you.
Now, we back to,
Judge, I believe we're ready also on Jerome Fitzpatrick. He signed in again.
okay.
Alexandria Poole here for Levante Seaborn. He's here on the Zoom.
Okay, what were we doing on Stewart?
Stewart is a sentencing. That was Mr. Cribb's case.
Why, we didn't proceed because we didn't have Miss Athena, right?
Right.
She's still not on the
I don't see
call.
her.
Okay,
So you wanna just go with back to Fitzpatrick?
yes.
All right, parties on Fitzpatrick. We're on the record with the matter of People versus Jerome Fitzpatrick. This is case 20-379201 FC. This matter before the court is a final pretrial.
Appearances?
Good morning, Judge. Ralph Elizondo on behalf of the people.
Good morning, Your Honor. Attorney Kevin Basant, P71061, on behalf of Mr. Jerome Fitzpatrick, who's also present by Zoom video.
All right, good morning to everyone. Mr. Fitzpatrick, state your name for the record.
Jerome Fitzpatrick. Good morning.
Good morning, Mr. Fitzpatrick. Okay, is there an offer from the people on this case?
The only thing I could say at this point, Judge, is the offer would be, have to be a plea to count one, carjacking. The people would be willing to dismiss the remaining counts. And the sentence, as far as the sentence, I would just be asking for something within the guidelines.
What's
And
the guideline?
unfortunately, I don't have the guideline scoring here, Judge.
Okay, well, the defendant won't have an opportunity to really make an educated decision without knowing what the guidelines are.
I understand. I would like to sit with Mr. Basant and kind of work through, make sure that we're both on the same track as to the scoring for that.
Okay, all right, so you guys need another date?
Well, we do, Judge, but if I could, Judge, I want to place a few things on the record, Judge, and no disrespect to the people, but one, this is the first time I'm hearing this particular offer. But more importantly, Judge, this matter has been adjourned several times, unless the people have an update with the forensic discovery. There was DNA evidence taken in this case months ago. The last hearing, Judge, we adjourned it 90 days to obtain that particular discovery or the results for that forensic report. And the reason why it's important is that DNA evidence goes to identity, Judge. In this case, the backbone of this case is identity. So before I understand a plea offer, Judge, but I need to know what the evidence shows so that me and my client can make an informed decision going forward. And I don't know.
All right, Mr. Elizondo, where's the DNA evidence?
I wish I could say where at this moment, Judge. I can make calls to the officer in charge and see where we're at on that.
Well, here's what I'm gonna say. When the evidence was submitted to the lab, your name should have been on there too, as a person that is involved in the case. I would suggest you contact the lab directly to find out, because dealing with the officer in charge, it seems like I said this before.
Yeah, Judge.
Dealing with the officer in charge is a lot of times not that fruitful. So I'm going to give another pretrial date, and at that time, this court needs to know exactly when the DNA results will be ready, if they are not ready for the defense, because this is a 2020 case. So this should have been, we should have received or at least know what the status is. This took place in March of 2020, so over a year ago. So I would suggest that the people contact the lab. I'm going to give another date. At that date, I expect to have the results should have been given to defense. Otherwise, we're going to have to start show causing individuals. All right.
The 18th, Your Honor.
June 11th.
June
9
11th.
a.m. That's going to be the last time we have an adjournment without knowing what the DNA is, without show causing. So I'm going to put a note in here for myself so I remember that. Is that it?
That's it for defense counsel. Thank you, Judge. We'll see you in June.
All right.
All right. Thank you, Judge.
Thank you. This matter is concluded.
Did you send it, Mr. Blanda?
Yes, I did. Did you get it, Crystal?
I got Mr. DeGrazia's. No, I did not get it.
Yeah, I sent it.
You got
DeGrazia sent a investigative report.
I sent it
You
to
must
Crystal
have
dot.
gotten some. Spell it for him.
Crystal, CRYSTAL,
Yes,
dot B as in boy, RIGHT.
right, at 3rdcc.org.
Correct.
I sent it, and I sent it from FedEx. I had to go to FedEx because my equipment isn't working, so I sent it from FedEx to you. I can resend it again.
Oh, well, I just don't have it.
I'll send it again.
Oh, FedEx office scan. I do see it.
Okay.
All right.
I do. I
Yeah,
have it.
you
Sorry.
probably should have let her know you were sending it from FedEx.
Okay.
Okay, we have it now.
And I would indicate, Judge, one thing that, unless I'm mistaken, the plea form that Mr. King had executed indicated this was an R&O at 4 years. It's really a 2-year, I believe.
Oh, it says 4 years.
Okay, well, I'll look at the plea form and we'll recall the case and we'll get that figured out.
Thank you.
Okay. Recalling People versus James Coleman. This is case 21-1249. This matter is a pretrial here to sleep.
Good morning, Judge. Richard Glander for Mr. Coleman, 32990. Mr. King was the prosecutor earlier. I don't know what happened to him.
Oh, my goodness. All right, well, we can't do anything without the prosecutor. So that's back to the burner. All right, who's ready with all parties?
You're right, John Casey on behalf of the people. I believe I saw Mr. Macled and Mr. Al Hassoun in the feed. I just emailed a copy of the signed plea form to Ms. Bright.
I have it. I'm printing it out now.
I believe we're ready on Levante Seaborn.
Seaborn. Okay, let's do Seaborn. Is Mr. Seaborn on the call?
Yes, he is, Your Honor. Mr. Seaborn, can you say something?
Oh, I do see it.
I don't see a Mr. Seaborn on this call.
He's under Vante. I've spoken with him this morning. I'll give him a call.
Is this on the docket today? Because I don't have Seaborn on my docket.
I don't either.
Oh, wait a minute.
Oh, do I have the wrong date?
I don't have Seaborn either.
I don't have the file. Let me look and see if
That's not on the docket today.
May I inquire? The
What's
case number, give me 1 second, Your Honor. I can also double check on Odyssey. I thought I had the right date on this.
Let me see. I got something that was on the desk here. This is case 23-248-02.
Yes, that's correct.
And it was with Hightower.
Oh, it's a co-defendant.
Yeah. I do see it scheduled for today, 5/7, but I just don't have the
It's
file.
not on my docket sheet. Is it on yours? Because I don't have
It's not on
Hightower.
mine either.
No.
Oh, yes, it is.
It's not on mine. It's on yours?
It's on mine. It's
What
on
is it
my
up
court
for?
sheet.
No, it's not on the one she printed out the daily document.
Okay.
What is it supposed to be up to?
Sentencing. It's a higher
Okay.
sentencing.
Ms. McCray, are you the prosecutor on it?
Yes, I am.
Okay, well, the problem though is I don't have that file has not been pulled and thus I don't have the print. So,
I understand we're not on the record yet on this case, but if we need an adjournment, we can do that. There was an issue with the investigator's report that's listed in the PSIR.
okay, well, we're gonna have to adjourn this because it's not on my docket at all. So, we'll adjourn it to June 11th.
Does it have to, I'm so sorry, does it have to go so far out? Because I know that this adjournment was a little long.
I believe, well, we don't have any dates left in May.
We got the 28th, Your Honor.
Oh, I can't do the 28th.
How many are on the 28th?
10.
Okay, we'll add it to the 28th. The thing is, Hope won't be here on the 28th, and so she didn't want a lot of stuff on there, but.
Your Honor,
Thank
I'm
you.
sorry, I'm not in the office on the 28th.
Okay, then we're going to June. June 11th.
And what is the problem with the PSI, Ms. Poole?
The investigator's report is incorrect. It's not the one for the case, and there's a whole another case that's attached to the end of the PSIR.
So do we
I'm
need to do
unsure
a
where it came from.
re-referral?
I'm sorry?
We need to do a re-referral then?
I was wondering if I needed to, or if it was just something that
let
could
me
be
ask you
deleted.
this. Is the case that's attached still his case? Because they attach all cases if it was not too long ago.
Right, it's not anything that he was charged for. I don't really see his name throughout. I see, and so that's why it was an issue. And in the
It's referring to somebody else? Is that what you're saying, Ms. Poole?
I'm saying that it's a little complicated for me to explain without you all being able to see it.
All right, we'll deal with it on June 11th. Issues? I don't know.
Ms. McCray, I'll give you a call.
Hold on, Ms. Schoen is on the call. Ms. Schoen,
Yes,
so the PSI is on, what's your client's name?
Levante Seaborn.
And she's indicating, I guess there's some information in the PSI that deals with another case that's not his. Now, I know a lot of times I'll get attachments and it'll have other cases connected to that defendant besides the one he's being sentenced for. Correct?
yeah, well, you know what, if you forward it to me with
Yes.
what corrections need to be made, I'll make sure they're done and include the new sentence date, and
Okay.
we'll have it done.
Hold on, we can't do corrections because the prosecutor would have to agree to whatever corrections they are. If you have any questions and you think it doesn't involve your client, you can forward it to Ms. Schoen and with a note indicating, I don't think this has anything to do with my client. But we can't do any corrections without the prosecutor.
Okay.
I understand. And like I said, it's a little lengthy, and so I will reach out to Ms. McCray before reaching out to Ms. Schoen.
Just put it in an email for me if you could.
Sure.
We'll get it worked out.
Okay.
Okay,
Thank you.
you're welcome. June 11th. All right, we have the plea form now.
I got the plea form for Coleman, and I also have the plea form for Hassoun.
All right.
Any
Oh, he didn't
update on
have-
Osborne, Your Honor?
I don't know, Ms. McCray was checking with Mr. Heaphy about that.
Are parties on Hassoun ready?
John Casey on behalf of the people. Yes, I am. And Mr. Macklin wasn't here earlier. Oh yeah, there he is.
That's probably
Yep.
Yep, sorry, we had to unmute. We are ready on Ali Hassoun.
Okay.
okay. For the record, calling People versus Ali Hassoun. Mr. Hassoun is here on cases 20-3955, 01FH, and 20-3956. And he's here for final conference appearances, please.
Good morning, Your Honor. John KCP number 56162 on behalf of the people.
Good morning, thank you, Judge Amir Macklin on behalf of Ali Afif Hassoun, who's present in my office.
Okay, good morning to everyone, and Mr. Hassoun, good morning to you.
Good morning, Your Honor.
All right, the court, it appears that the parties have reached an agreement. Mr. Prosecutor, would you put the terms of the agreement on the record?
Yes, Your Honor, I will. The plea agreement is as follows. As soon as it opens up. Mr. Hassoun will be pleading to count one, which is, I believe it's possession with intent to deliver a controlled substance in an amount less than 50 grams. That's a 20-year maximum felony. People are agreeing to dismiss counts 2 through 5.
Hold on, Mr. Casey, on which case number?
I'm sorry. Yeah, the case number he's pleading on, I have is 20-003956.
Okay,
Okay, we're going to dismiss counts 2 through 5 on that case, withdraw the habitual second offender notice. We're also going to dismiss case number 20-003895 in its entirety. The sentence agreement is as follows: a 3-year term of probation, which will include community service, the number of hours determined by the court, costs and fees, of course, as required by statute, drug treatment if recommended by probation, and we're going to ask that that be, we suspect it's going to be recommended, and that it continue with the drug treatment until medically discharged. We're asking for any substantive violation of probation, specifically, what do we mean by that? Another felony narcotics offense. We'll be recommending for that violation of probation a sentence of 1 to 20 years in the Michigan Department of Corrections for Mr. Hassoun.
all right, defense, is that your understanding of the plea offer?
That, yes, Judge, and also we indicate that the case of 3895 will be dismissed against him.
Yes, that's on the plea form. All right,
Yes, that's our full
Mr.
understanding.
Mr. Hassoun, is that your understanding of the plea offer?
Yes, Your Honor.
And you've had an opportunity to discuss this with your attorney?
Yes, I have.
All right, Mr. Hassoun, I need you to raise your right hand.
Mr. Hassoun, do you solemnly swear or affirm that your testimony in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, Mr. Hassoun, how old are you?
25?
I'm sorry?
25.
Okay, and how far did you go in school?
High school?
Did you graduate?
No.
All right, are you a U.S. citizen?
Yes, I am.
Do you read and write the English language?
Yes.
And do you understand what's going on here today?
Yes, I do.
All right. I have in front of me and a settlement offer advice of rights notice of acceptance form, which indicates that the people are offering that you can plead on case number 203956. You can plead to count 1, controlled substance delivery manufacture less than 50 grams, which is a 20-year offense. The people will then dismiss counts 2 to 5. Also withdraw the notice to enhance sentence, habitual second. And there's a sentence agreement of 3 years probation, community service, the numbers to be determined by the court, drug treatment if recommended by probation, and any substance violation of probation, and I think they mean substance abuse. The people recommend 1 to 20 years in Michigan Department of Corrections. The people also will dismiss case 20-003895. Is that your understanding, Mr. Hassoun?
Yes, Your Honor.
All right, are you satisfied with your attorney's representation?
Yes, I am.
All right, when you spoke with your attorney on this advice of rights, there are some rights that you'll be giving up by taking a plea today, and I'm gonna go over those. You are giving up the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at court, to question those witnesses against you, to have the court order any witnesses you have for the defense to appear at trial, to remain silent during the trial, to not have that silence used against you, and to testify at trial if you so chose. You understand you're giving up those rights?
Yes, I do understand.
If the plea is accepted, you will be giving up any claim that the plea was the result of promises or threats that were not disclosed to the court at the plea proceeding, or that it was not your own choice to enter the plea. Do you understand you're giving up that right?
Yes.
If your plea is accepted, you will be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. And any appeal from your conviction and sentence will be by application for leave to appeal. So what the second half of that means is, by you taking a plea here, if you want the Michigan Court of Appeals to review the circumstances surrounding your plea and sentence, you'd have to ask them, and it's their right whether they choose to do it. If you went to trial and were found guilty, it's an automatic right of review by the Court of Appeals. So by pleading guilty, you give up that automatic right of review. Do you understand you're giving up that right?
Yes, Your Honor.
Knowing and understanding all the rights we just went over, is it your wish to give up those rights and plead guilty today?
Yes, Your Honor.
Has anyone promised you anything other than the plea agreement to get you to plead guilty?
No,
Has anyone threatened you or coerced you in any way to get you to plead guilty?
no,
Are you pleading guilty of your own free will?
yes,
Are you currently on probation or parole to this or any other court?
no, Your Honor.
All right, Mr. Prosecutor, can you ask questions to establish the factual basis?
Will do. Mr. Hassoun, can you hear me okay?
Yes, I can.
Okay. I'm going to ask you a series of questions. If you can't hear them, let me know, okay?
Okay.
All right, Mr. Hassoun, I want to direct your attention back to July the 18th of last year, 2020. On that day, at about 3 o'clock or so in the afternoon, were you in the area of 14545 Ford Road in the city of Dearborn, Wayne County? That's the Exxon gas station there. Were you there?
Yes, I was.
And were you in a vehicle?
Yes,
And whose vehicle was that? The black Acura?
it was my vehicle, but it was under my dad's name.
I got you. And on that day, did you have possession of a number of pills?
Yes, I did.
And were 48 of those pills or so hydrocodone?
Yes,
And was it your intention to share, give, or sell some or all of those hydrocodone pills to somebody else?
no,
Were you going to distribute or otherwise deliver some or any of those pills to other people?
yes,
People are satisfied.
Defense,
Satisfied.
is there a stipulation that it was less than 50 grams?
We'll stipulate to that. Yeah.
Defense,
Yes.
okay, both parties are satisfied?
We are.
Has the court complied with Court Rule 6.302?
It has, Your Honor.
The defendant will be referred to probation department for a pre-sentence report. Mr. Hassoun, you need to contact probation. That number is 313-456-4600. Your next sentencing date will be
June 18th, Your Honor.
June 18th at 9 a.m.
That's good for the people.
456 4600, Judge.
Yes, 456-4600.
Okay, thank you, Your Honor.
All right, anything further?
Nope.
No, Your Honor, I'll email a copy of the investigator's report to your court clerk right now.
Thank you.
And could you copy that to me as well, please?
Can do.
Thank you, bye.
Are we ready on Mr. Cripps' case? Which was a sentencing on Martin Stewart. Are we ready on that? Oh, wait a minute, Mr. Cripps, is Mr. Cripps here? I think Mr. Cripps is gone now. All right, who is ready with all parties? No one.
I'm just checking on Osborne to see if anything from Mr. Heafy, because she has to be at work.
Okay, Ms. McCray, have we heard from Mr. Heapy?
Your Honor, if I may say a word.
Hold on one second, Ms. McCray. All right, Ms. McCray is not on the phone. Mr. Stewart, are you asking the court something?
Yes, ma'am.
Go ahead, Mr. Stewart.
Thank you, Your Honor. I'm just curious if I have any idea when the prosecutor may be available. I am at work.
I do not, because that's the prosecution office. I'm not connected to them. I can ask Ms. McCray if she was able to get a hold of Ms. Mathena. But Ms. McCray is not on the line right now. So
I come back.
nothing I can do at this point, but wait for. Well, let's wait till the court prosecutor comes back to see if we know.
Judge, I have not been able to get in touch with her. I emailed her, but I haven't heard back.
All right, Mr. Stewart, I understand you're at work. Your attorney is also not on the line right now. So you want a different date?
No, I want this to be, it's been going on for 2.5 years. I just want this to be over today.
Well, yeah, it would. I don't know why the prosecutor isn't on the line at all.
Judge, do you have on in the file on the plea form, which prosecutor signed the plea form?
Do you have the Stewart file?
I have a plea form. Did I give it to you, Judge?
I gave the file, but wait a minute, let me see, is this it?
I don't see
Okay,
a
hold on, I
signature.
have it.
I can't.
Let's see who signed this.
There you go, 'cause I can't tell who signed it.
We can't tell who signed this. It's, I don't know, I can give you the P number, 34972.
Could you say it one more time?
34972.
Okay, perfect.
I don't think that's Miss Matheny. I don't think her P number is a 3.
Even Judge Knapp is not there. I mean, that long.
Yeah, I don't think it's her.
But she's the prosecutor because it's a or a child abuse, I mean. Andy.
Judge, I believe Mr. King is back. I'm Coleman, ma'am.
I am.
All right, let's do call.
Okay. We're on the record with the matter of People versus James Coleman. This is case 21-124901FH, and this matter before the court is a pretrial. Appearances, please.
Yes. Good morning, Your Honor. Larry King for the People, P78774.
Good morning, Judge. Richard Glanda, 32990 for Mr. Coleman. He's on the call, ma'am.
Coleman, state your name for the record.
James Coleman.
Okay, I have a plea form in front of me. However, there seems to be maybe an issue. Mr. Prosecutor, please put the terms of the agreement on the record.
Yes, Your Honor. The agreement is to plead to count 1 of the amended information, which has been filed and emailed to the court, that being resisting and obstructing, with an agreement of 2 years probation. Count 2 would be dismissed.
What's the statutory maximum on the resisting obstruction?
It is a 2-year. It is a 2-year maximum, Your Honor.
It says 4
That's
years
not
on the
what's on your plea form.
I apologize for that. I can edit that myself.
The court can change it if there's no objection from the parties.
No objection, Judge. It should be a 2-year.
No.
Okay, so it's a 2-year max. The court has made that change in initial. I need the amended information. He said he found.
I'm looking for it, Judge. I pulled up the case. I should be able to see it, but I don't see it.
We don't have the amended information yet.
I had sent it to the Judge Baker-Court email address. Is there a different email address I should send it to?
If you e-file it, it should come up on Odyssey.
I did e-file it, and I received the e-file confirmation as well.
It hasn't come through yet. Okay, all right. Yeah, if you send it to me, that means I have to. Okay, Tom, Mr. Stewart, Miss Mathena, who is now handling, is coming on, so hold on a second. Let me see if I can pull it up.
Thank you, Your Honor.
Yeah, that's not the email to send it to. I'm gonna show him. Last email I got is 10/23. And those are job. Nope, I don't have it. You need to send it. We can continue with the plea, but I need it by the time we finish. You can send it to Crystal. That's the clerk that's here today. She can spell her name for you.
Is that Crystal Sanford?
No, Crystal Bright. BRIGHT. Crystal.bright at 3rdcc.org. Good, I ain't got too long yet.
Sending it now.
Thank you. Yeah, that's what I'm saying. I'm like, God damn.
Okay, who's ever got their phone on and is talking, we are in middle of court. Please turn your phone off.
Miss Bright, that has been sent.
I see it. I got it. I have it now.
Wonderful.
All right, let's continue with the plea. All right, Mr. King, did you put the rest of the terms on with respect to what's being dismissed and the probation, the sentence agreement?
Your Honor, I believe I did. The agreement is, again, to plead to count one of the amended information, dismiss count two. There's an agreement to a 2-year probationary term.
All right. Defense, is that your understanding of the agreement?
It is, Judge. Thank you.
All right, Mr. Coleman, is that your understanding of the agreement?
Yes, ma'am.
All right, you discussed this agreement with your attorney?
Yes, ma'am.
I say, raise your right hand.
Will you solemnly swear or affirm that your testimony in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, how old are you, Mr. Coleman?
I'm 60. Well, I'll be 61 on the 25th of this month. So I'm 60 right now.
Okay, and how far did you go in school?
I got my GED and I went to college.
Okay, and do you read and write the English language?
Yes, ma'am.
You understand what's happening here today?
Yes, ma'am.
All right, and are you satisfied with your attorney's representation?
Yes, ma'am.
All right, the original charges in this matter were assault with a dangerous weapon, felonious assault, 4-year max, and police officer resisting, obstructing, 2-year max, and domestic violence. And the people have offered that you can plead to resisting and obstructing, which is a 2-year max. They're going to dismiss count 2. Well, it wasn't police officer. Wait a minute. Let me look at the amended information. All right, so count 2, it was amended. And so the amended information was count 1, police officer resisting and obstructing, which is a 2-year max. And domestic violence is count 2. The people are dismissing the count 2 domestic violence. And there's a 2-year probation, fines, costs, and other terms and conditions of probation to be determined by the court. That's your understanding of the plea, is that correct?
Yes, ma'am.
All right, you'll be giving up certain rights by pleading guilty here today. You'll be giving up the right to be tried by jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question the witnesses against you, to have the court order any witnesses you have for the defense to appear at trial, to remain silent during the trial, to not have that silence used against you, and to testify at trial if you so chose. You understand that you're giving up all those rights?
Yes, ma'am.
If your plea is accepted, you'll be giving up any claim that the plea was the result of promises or threats that were not disclosed to the court at the plea proceeding, or that it was not your own choice to enter into the plea. You understand you're giving up that right?
Yes, ma'am.
All right, and if your plea is accepted, you may be giving up the right to appeal issues that will otherwise be appealable if you were convicted at trial. You're also giving up the right to for an automatic appeal, and you have to ask for leave to appeal. So what that means is, if you want the Court of Appeals, the Michigan Court of Appeals, to look at your the surrounding circumstances around your plea and conviction and sentence, you'd have to ask them, and it's up to them to look at it. If you went to trial and were found guilty, it's an automatic review. So you understand you're giving up that automatic review?
Yes, ma'am.
Knowing and understanding all the rights we just went over, is it still your wish to give up those rights and plead guilty today?
Yes, ma'am.
Other than the plea agreement, has anyone promised you anything else to get you to plead guilty?
No, ma'am.
Has anyone threatened or coerced you in order to get you to plead guilty?
No, ma'am.
And are you in fact pleading guilty of your own free will?
Yes, ma'am.
Are you currently on probation or parole to this or any other court?
No, ma'am.
All right, prosecutor, please, ask questions to establish the factual basis.
Thank you, Your Honor. Mr. Coleman, I want to turn your attention to January the 4th of 2020. On that date, were you at or near 333 Goodell Street, City of Riverview, County of Wayne, State of Michigan?
Yes, that's my home.
And did you have contact with police on that date, sir?
Yes, I did. I let them in.
Okay. And were those police officers identified as police and in full uniform?
Yes.
And did those police officers ask you to comply with commands such as putting your hands up and stopping?
Yes.
And did you willfully fail to comply with those commands?
No, I didn't.
Okay. Did these police officers attempt to detain you or arrest you?
Yes, they did.
And did you physically resist the attempts for them to detain you and arrest you?
No, I couldn't because they was twisting my arm to the point of breaking them. One had one arm, another had the other. They were pulling me back and forth, saying, quit resisting. I said, how am I resist? Man, I'm not resisting.
So you didn't resist?
They would twist my arms. I couldn't put them behind my back because the way they was twisting them.
Mr. Coleman,
Yes, ma'am.
did the police ask you anything during any of your encounter with them to do something that you did not do?
No.
So you're saying that you didn't resist and obstruct them, right?
No, I didn't. But
Okay,
I
then
just
why are
want
you
to,
pleading
Your Honor,
guilty, Mr.
because I want to get this over with, Your Honor.
Okay, well, the court cannot take a plea if you are not guilty. So that being the case.
No,
that
Your Honor,
concludes
I'm
the
guilty. I'm guilty, Your Honor. Let's just get this over with, please.
No, we're not doing that. If you're saying to this court, you did everything that the police asked you to do, you didn't physically move your arm or resist in any way, then the court can't take a guilty plea on that. Just to get it over with, we're not gonna do that. So, what do you all wanna do? Are we doing the trial readiness or what?
I turn to Mr. Glanda on this. I'm not sure how he wishes to proceed.
Well, the court can send you out a trial readiness form that you all can complete. Unless you all can come up with some other, the only other charge here is domestic violence. I don't know if the people are willing to give them a plea to that, if that actually happened. But the court can't take a plea on resisting and obstructing. The defendant is maintaining his innocence.
Perhaps I would need to explore further settlement with my supervisors. Perhaps we could put this on the trial readiness track, but while we're preparing that trial readiness form, Mr. Glanda, myself, and my supervisors could continue to discuss the case, and we could maybe get another date to come back.
Okay.
Judge,
That's what
either that or if you could put me in a breakout room for a moment with my client.
Nope, I'm not gonna do that, Mr. Glanda, because your client is vehemently denying doing anything contrary to what the police asked him to do. And he said he's only pleading to get it over with. And as the judge in this matter, I cannot take a guilty plea from him unless he's not being truthful, but he seems to be pretty adamant to me. So that being the case, we're gonna adjourn this for you all to see what you all can work out, unless you talk to Mr. Coleman and he indicates that, he's not telling the truth. I don't know who's telling the truth, but what I know right now is he's vehemently denying that he did anything. And he specifically said he's only taking the plea to get it over with, so the court cannot take that plea. So we're gonna give you a new date. How many minutes we have on 11?
Right now, 9.
Okay, June 11th at 9 a.m. And the court is gonna have the JA send the trial readiness form. And we can send that out to you. And if something is, you all can come up with a charge that Mr. Coleman can say he actually did, then we'll see you back. All
Very
right.
well. Thank you, Your Honor.
Larry,
Thank
call
you.
me, okay?
After my Zooms, I will.
This matter is concluded, Mr. Coleman. You can hang up.
Okay, thank you.
All right, Mr. Martin Stewart, who looks like he's in the middle of working. And I understand you're working, Mr. Stewart. I can't hear you though. Your phone is muffled. Ms. Hinterlang, is Mr. Stewart, is that your case?
That's my case, Judge. My understanding is that Mr. Cripps is currently doing a live hearing in front of Judge Bridget Hathaway.
Oh, well, it looks like we just might have to get another date then. Mr. Stewart? Mr. Stewart?
2.5 years, Your Honor, I've been going through this.
I can't hear you, Mr. Stewart. Your phone's
Yes,
going
Your
in and
Honor.
out.
I'm wondering how much, yes, ma'am. Can you hear me? Yes, ma'am.
Okay, I
Can
can
you
hear
hear me?
you now, Mr. Stewart. Go ahead.
Can you hear me well?
Yes.
Or should I go outside? Okay, I just wondering if this is gonna go on forever. I wonder if I should just go to trial. I mean, this is taking 2.5 years, Your Honor. 2.5 years.
A lot of things are taking a while because of the pandemic, Mr. Stewart, so it wasn't much we could do about that. Your attorney is in a live hearing right now.
Yes, ma'am.
So that being the case, we can do one or two things. If you want to
Dismiss
get
it?
it done today, we can reschedule. I can let you go ahead and go back to work and we can reschedule for this afternoon and you see if Mr. Cripps is available and come back today. Otherwise, we need to give you a different date because he's in a live hearing right now.
Your Honor, I would love to come back in the afternoon.
Okay. All right.
What time
Ms.
should I be
Hinderlane.
on?
Hold on one second. Ms. Hinderlane, can you send a text to Mr. Cripps? I'm gonna let Mr. Stewart go, but I'm gonna set it right now for this afternoon at 2 o'clock.
Thank you, Your Honor.
Okay, and Judge, that's fine. I can have it might not be me, it might be somebody else standing in for me, just FYI, but we'll let you know. I also did not receive the PSI. Could I either come and pick that up at 1 o'clock or have it emailed to me?
Sure. You can do either one. I do have it. Okay. That's fine. So you can come pick up a copy if you want, or you can have an email. Either way, whichever one you want.
Email would be great.
Okay. We may not get a chance to email it till we finish it today, but we'll get it.
That's fine. Thank you.
All right. Let Mr. Cripps know that we reschedule it for 2 o'clock this afternoon.
Already done.
Yes, ma'am.
Thank you.
Thank you.
Thank you, Your Honor.
Bye-bye. All right. Who's ready?
Your Honor, any news on Osborne?
Yes, yeah, Mr. Heafy sent the order dismissing it and CC'd brother counsel, and he sent it to Hope.
Hope's not here today.
Oh.
Hope's not here.
Okay.
Can you send it to Crystal?
Yes, I will. Let's see, Crystal. Okay, I just sent it to Miss Crystal.
Okay.
Oh, did it not?
Okay. Yeah.
See, hold on, I don't see anything attached though. I don't see anything attached, Miss.
I just resent it.
Email.
I just resent it to you.
Okay. I got the email, but there's just nothing attached to it.
Yeah.
There it is.
Yeah.
Now it's attached. All right. For the record, this is case 20-292701FH, People versus Kiara Osborne. This is the date and time scheduled for a diversion review.
Appearances.
Good morning, Your Honor. Andrea McCray hearing on behalf of the people.
Good morning, Your Honor. Respectfully, Attorney Yellow, on number 66874 on behalf of Ms. Kiara Osborne.
Kiara Osborne here.
Ms. Osborne, can you please turn your camera on?
1 second, please.
Okay, you have it.
It's all printed out, huh?
Can you see me now?
No, I can't. We only can see the iPhone. You have to turn the camera part on.
Good morning.
Okay, I can see you now. Good morning, Ms. Osborne.
Good morning.
All right, I'm waiting. Hold on. We're having a problem with the printer again.
Oh, okay. This is it right here. Yeah. It went to the Zoom. That's what it was. The zebra printer, I mean.
All right, the court has motion in order to dismiss charges and destroy fingerprints and arrest cards. The court is signing the order right now, and Ms. Osborne is off the version. And the case is closed.
Thank you, Your Honor.
Thank you, Your
You're
Honor,
welcome.
so much.
Good luck, Ms. Osborne.
Thank you. Have a good day.
You too. Anybody else ready?
Judge Baker, this is shown with probation.
Yes.
Mr. Efford has been on to address a show cause.
Okay.
But I've looked into it, and I would like to set the show cause aside and have his case closed with improvement.
Okay, where's Miss, we have to call it.
Okay, I printed out the show cause. What do I do with it?
Oh, I don't think I have it. You have it?
I printed it. This is not it. There, I got it.
Okay.
The show cause. All right, for the record, calling case 18-96959-01FH, People versus Brian Efford. This is the date and time scheduled for a show cause hearing. Appearances?
Good morning, Lori Schoen, Department of Corrections.
Where's Mr. Efford? You got, you're muted, Mr. Efford.
Good morning, everybody.
Good morning. State your name for the record.
Brian Efford.
Do you have an attorney, Mr. Efford?
No, I do not.
All right.
I could have had
closing
one.
it out, Ms. Shawn?
Pardon me?
You're just closing it out?
Yes, Judge, we'd like, yeah, he is in compliance. We would ask to close the case out with improvement.
Do we need to get an attorney online if we just closing it out?
No, Your Honor.
Okay, then it will be closed out.
Thank you.
All right, Mr. Efford, your case is closed out.
Thank you. Have a great day.
You too. All right.
Anything else?
Nope. Anybody else ready? Doesn't look like it. We have sentencing. Oh, Ms. Poole got adjourned, right?
Yeah.
All right.
And the sentencing that too.
That's on Stewart.
Right.
And then I have a Miller sentencing.
That too? Oh, yeah, nobody
No.
ever checked in on that.
Nobody is checking. We need to call the lawyer.
There's Ms. McCray.
Where's Mr. Miller?
That's Mr. Frost's case. He's usually always.
All right, so what has not been done? I am showing that we have not done.
I'm Mr. Miller.
All right, Mr. Miller, we need to get your attorney on the line.
Yes, I did text him. I told him that I was in here, but he hasn't responded yet.
Okay. So Mrs. Seaborn is the one that we adjourned. to 6:11. And Stewart is adjourned to 2:00. Is that it?
That's it.
Here's Mr. Frost right here. We should be able to get that done.
Excuse me, are we doing it, Mr. Allen?
Mr. Allen,
Mr. Allen was, changed to 6:11 according to this.
I don't even know why Mr. Allen is on there. It's just a motion it's a motion that the court just has to sign the decision on it and send it out. So I don't know why we'd be calling it. We're not doing Mr. Allen, and I don't think we will.
Okay.
Okay. Mr. Allen's response will come from the court. Court has signed it already. It's gonna be sent to the defendant.
Everybody ready on Miller?
Okay, they just sent the letter in the mail, so they told us. So when I spoke to the detective, she told me to watch for appeal.
Oh, wait a minute. Hold on. I'm thinking of a different case. Mr.
Yeah,
Allen.
Damon Allen.
Yeah, Damon Allen. He's been changed to June 11th, but I think the judge that was previously on it is probably gonna have to do it. But it's been changed right now to June 11th at 9:00.
Okay.
Okay, thanks.
Thank you.
All righty. We ready on Mr. Miller?
Parties on Miller?
Ready?
Okay, we're on the record with the matter of People versus D'Angelo Miller. Mr. Miller is here on case 20-4430, and he's defendant 2. And he's here for sentencing on that case, and he's also on probation to this court on case 18-8707. Appearances, please.
Good morning, Your Honor. Andrea McCray appearing on behalf of the people, number 83698.
Your Honor, if I please the court, Wayne Frost representing Mr. Miller.
Okay, and Mr. Miller, please state your name for the record.
Angelo Miller.
All right. This is the date and time set for a sentencing in this matter. Mr. Miller, do you consent to be sentenced over Zoom?
Yes.
Okay. All right. Have the parties had an opportunity to review the body of the pre-sentencing report?
Yes, Judge.
Your Honor, I have. However, I have not gone over it with my client. I apologize to the court. I was on earlier today and had to Zoom off to do something else. If I could go to a breakout.
Wait,
Yeah,
has your client seen the report at all?
No, I need to go over it with them, Judge.
Okay. All right. You want me to put you in a breakout room?
Yes, please.
All right.
It shouldn't take very long. I've gone over things with my client, but I just need to make sure.
Okay.
This is the previous order for the show cause effort.
The one that we just closed out?
Yes.
So I need to sign it as closed out.
Huh?
I'm signing it as closed out.
Right. I put it at the top. I'm trying to highlight it. So,
Oh, okay. All right. Here's Seaborn's.
Okay.
All right, I'm gonna take a break. Brief break. All right, is everybody ready?
People are.
Ready, Judge.
Okay.
Yes, I'm here.
All right. The court is recalling. Hold on one second. Case number 2000443002. People State of Michigan versus D'Angelo Miller. This is set for sentencing. And then there is a probation case of 1800870701. All right.
Sorry, Judge, I had to
Oh, that's great.
make these grown folks at my house do some stuff.
Okay, so the court has the, when we were, put your appearances on the record first, please.
Andrea McCray appearing on behalf of the people for the pending active case.
Your Honor, if I please the court, Wayne Frost representing Mr. Miller.
And Mr. Miller, state your name for the record.
D'Angelo Miller.
All right, when we were about to do the sentencing and it come to the court's attention that Mr. Miller had not gone over the pre-sentence investigation report with his attorney, the court then stopped to allow the attorney, Mr. Frost and Mr. Miller, to go into a breakout room. Did you all have an opportunity to go over the pre-sentence investigation report?
We did, Judge. It is factually accurate. However, when it comes to the guideline, there are no additions or deletions to the main body. However, when it comes to the guidelines,
We
was,
haven't gotten to the, hold on, we haven't gotten to the guidelines yet. So
okay.
let's just deal with the body of the report. So there are no additions, deletions, or corrections to the body per defense.
No, Your Honor.
Madam Prosecutor?
There are no deletions or corrections to the body.
Okay, now, Mr. Miller, you went over the pre-sentence investigation report with your attorney,
Yes.
and you did, was it factually accurate?
Yes.
All right, here's the one thing though. It says that the probation department contacted the victim who indicated basically $150 or $200 was taken from him. This was an unarmed robbery. I do not know if they talked to the victim why it was not set at $200 restitution. So
if I may, I had talked extensively with the victim, and he had told me that everything was covered through his insurance, and he had said he had some cash that he didn't know in the amount that was taken. And I told him that we couldn't, if we didn't have proof of what was taken, we couldn't set a restitution amount. And he indicated he understood. So that is the first time I'm hearing of an exact number. But I've already, I don't think it's fair to put that on defense at this point.
all right, well, I don't have the actual agent because the agent has on here that he admits that between 150 and 200 was taken. So I don't, well, okay. Well, if he doesn't give you a right amount, then I guess that's what it is. All right, now as to the guidelines, Mr. Frost.
Yes, Ms. McCray contacted me even before I had a chance to go over the guidelines and informed me there was a correction. I agree with that correction, and that is OV7, Judge. We both agree that that should be 0, not 50.
OV7 should be 0. Okay, the court will change that. So that changes the OVs to 20 instead of 70.
That's correct.
And what does that change the level to?
Oh, let's see.
I would, yeah.
It's in my email. Hold on, let me look at my email. I sent you. No, it's not. I have it in my car. Sorry, just 1 second. Yeah, level 2.
Level 2?
Yes, Your Honor.
All right, what about the PRVs? Are the PRVs correct?
I
Yes, Your
don't
Honor.
have any corrections on those.
Okay, so it's C2. So what are the guidelines now?
Judge, I believe they're 12 to 24.
And that's correct, Judge.
Okay, cool, we'll put 1224, stipulated to by the parties. All right, Madam Prosecutor, anything you'd like to say before the court imposes sentence?
Yes, Judge. So two things. So now that we've changed the guidelines, there is a correction to the body of the report on page under evaluation and plan, the second page of evaluation plan, the first sentence.
Okay, so it should be 1224.
Right, and that's the only change I had.
All right. Is there anywhere else in these guidelines or in this report that gives the guidelines? I thought there was another place.
I don't remember seeing anywhere else.
Yeah, we can double check.
Okay. Anything else, Madam Prosecutor?
Yeah, at this time, Judge, the people would move to dismiss count 2, and we would move to withdraw the habitual offender second offense notice.
All right, defense, no objection, I assume.
No objection.
That will be granted. All right, is that it, Madam Prosecutor?
Yes, Judge, thank you.
Defense, is there anything you'd like to say before the court imposes sentence?
No, Your Honor. We do have a sentence agreement in this matter.
Okay. And you will ask the court to follow the sentence agreement?
Yes, Your Honor.
All right, Mr. Miller, is there anything that you would like to say?
Not at this moment.
All right, well, the court is going to follow the sentence agreement. But I am going to tell you, Mr. Miller, that I was disturbed by this case. Your actions in this case. So what I want to tell you is do not come back before me while you're on probation. You understand, Mr. Miller?
Yes, I do. I understand.
Are you working, Mr. Miller?
Well, due to the fact that I'm on tethered, I'm not working now.
Well, I don't know if tether has anything to do with that. You could still have requested hours to be out. There's plenty of jobs. It's on the news every day. They can't even find people to fill the jobs.
No,
I'm
definitely willing to work. I've been trying to go back.
All right. The court is going to sentence you pursuant to the sentence agreement, which is serve 2 years probation with the first year in the Wayne County Jail. You must not use or possess alcoholic beverages or other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site, unless the field agent has first given you written permission for your employment at a specific location. You must comply with the requirements of alcohol testing as directed by the field agent. And you must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. And you must present proper identification at the time of testing. You must comply with requirements of drug testing directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. And you must present proper identification at the time of the testing. You must attend AA, NA, or CA meetings at the frequency required by the agent. Is there any indication here that Mr. Miller has a drug or alcohol issue?
No, Your Honor. However, it's my understanding, at least according to the report, alcohol was involved in the original incident.
Okay, all right. Well, if the field agent believes that there is a problem, then Mr. Miller will have to attend meetings, but other than him having alcohol being a part of this incident, I'm not sure if that's the case. If there's a problem and you're referred to an outpatient or residential substance abuse treatment program that you're referred to by a field agent, then you must go to it. You must complete a substance abuse assessment if you are referred, or when you are referred by the field agent. You must not engage in assaultive, abusive, threatening, or intimidating behavior. You must submit to the search of your person and property, not limiting to your vehicle, residence, and computer, without the need of a search warrant if the field agent has reasonable cause to believe you have items which violate the conditions of your probation. You must not have verbal, written, electronic, or physical contact with Gary Lewis, either directly or through another person, and you must not be within 500 feet of their residence, school, or place of employment. Look at something else. You must not have verbal, written, or electronic, or physical contact with Ebony Wilson, either directly or through another person. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours per week unless engaged in an alternative program approved by the field agent. You must provide ongoing verification of employment or alternative program to the field agent, and you shall not give reason to be terminated or voluntarily terminate your employment or alternative program unless you first obtain written permission from the field agent. You must serve jail time as follows: first year with a credit for 158 days served. Mr. Miller, do you have your high school diploma?
Yes.
Where'd you graduate from?
Central High School.
Okay. You must consent to assignment of wages until court order assessments are paid in full, unless otherwise directed by the field agent. You must pay $68 state costs. You must pay a crime victims assessment in the amount of $130 as ordered by the court. I understand you're not working right now, so the court cost would normally be $1,300. I'm going to reduce yours to $300, but I'm going to leave them there because I want you to get a job and you need to be responsible for some of these fees. Okay, Mr. Miller?
Yes, ma'am.
And you must pay attorney fees in the amount of $400 as ordered by the court. I'm going to waive your attorney fees. So you got a break, but that means I want the rest of the fees paid, okay?
Yes, understand.
You must pay $30 per month fees, supervision fee.
Yes.
It is my duty to inform you to advise you that you have a right to request leave to appeal from the Court of Appeals to appeal your plea and sentence. If you are unable to afford an attorney to prepare post-conviction motions or perfect an appeal, this court will appoint an attorney for you at public expense and will provide that attorney with such portions of the transcript as that attorney may require to prepare the motions for an appeal. You are further advised that if you wish to file an appeal or motion, a request for an appointment of an attorney must be made in writing and filed with the clerk of this court within 42 days of today's date. Let's see.
Your Honor.
The clerk is going to email the advice of appellate rights form to your attorney, who will forward it to you. Does your attorney have permission to initial the form on your behalf, acknowledging your receipt of the form, Mr. Miller?
Yes. Your Honor.
This is a form that you must file with the clerk of this court within 42 days of today's date if you wish to appeal and need to have counsel appointed for you. If you do not wish to appeal, you do not need to send the form in. Mr. Miller, are you calling me for something?
Yes. I don't know if this is wrong to ask, but I was just asking is there any way that possible that the time credit could be enough and not just do the probation?
No, it's a sentence agreement that's been entered into between your attorney and the prosecutor's office, so the court cannot change that. But I will tell you this, you are getting a break, Mr. Miller, because your guidelines are prisonable, which is where you should be going based on your guidelines. So if I were you, I would do that time that you have left. You've got 158 days credit, so you don't have that much time. So, no, I can't do it. It's a plea agreement you all entered into. Court can't change that. Okay?
Mr. Miller, call me. We can talk in just a moment, okay?
Okay.
What about his probation case, case 18?
Oh, yes, Ms. Schoen, the probation case.
Judge, we would ask to close without improvement.
No objection.
The court is gonna close the probation case without improvement. But Mr. Miller, please take what I'm telling you seriously. You have
Yes.
prisonable guidelines. This is a 15-year offense.
Yes.
You will be on probation for 2 years, some of which will be in Wayne County Jail. When you come out, matter of fact, when you come out, I want to see you because I want to make sure that we have you headed in the right direction. Because if you
Yes.
come before me again, Mr. Miller, you're gonna be heading to the Michigan Department of Corrections. Understand?
Yes, I do understand.
All right. And I don't want to see you head that way. There's enough people in there as it is. Hopefully you don't, we want you to be a productive citizen. So,
Yes.
let's see if he has 100. I'm going to say that I want to see you come back to this court on a review date in a year. Yes, a year from today.
Mm-hmm. Yes.
I'm about to give you a date. You give it to your mother, give it to your auntie, your grandmother, somebody, so they can remind you of this date.
Well, May 6, 2022 is a Friday, right?
That's fine. May 6th, 2022. Okay?
Yes, I'm writing it down.
And it's considered a court date, so I expect you to be here. I don't want to have to come looking for you. May 6th,
No.
2022. When you come in May 6th, 2022, I want to know what's going on with your life. So we can make sure that you get yourself together. All right, Mr. Miller? I don't want to see what happened on this case again.
Yes.
That was egregious. Okay, Mr. Miller?
Yes. I'm definitely taking what you're saying in.
Okay.
Judge,
See you in a year.
when would you like him to turn himself in, Judge? And where?
Oh, yes. You need to turn it's at Dickerson, Miss Schoen, or Wayne County Jail, doesn't matter.
Yes, Judge. Division 1, because they're moving everyone out of Dickerson next week.
Say that again?
I said he should turn himself into Division 1 because it's my understanding they're moving people from Dickerson to the jail. They're moving people out of Dickerson next week.
Okay, so Division 1, is that the new jail?
Yes, Judge.
Across the street from Frank Murphy?
Yes, Judge.
Okay, turn yourself into the new jail, Mr. Miller, on Monday.
Okay. So I just go down there?
Yeah, you just go down to the jail. They'll have the paperwork.
And
okay.
So
Now, I'm sorry, Mr. Miller.
I was just seeing how much was left remaining.
Well, subtract 158 from 365. 365 days in a year, you subtract the 158. About 200, approximately 200 days.
And Mr. Miller, when you call me in just a minute, we'll talk about that.
Okay?
Yes.
If the jail decides to let you out, that's on the jail, but you have to go, and that is your sentence agreement. All right, nothing further? This matter is concluded.
Can you put us in the breakout room, or you want me to call you a different way?
No, you're out. Your attorney can call you when you hang up.
Oh, okay. All right.
All right. Have a good day. Good luck to you.
Thank you.
Thank you, everyone. Have a great day. Mr. Miller, I'll call you in just 1 minute.
All right.
All right. Is that it?
That's it. concludes until 2:00.
To 2. All right, Ms. McCray, we are in recess until 2:00. Mr. Stewart, did you hear from, did you text Mr. Cripps?
No, but Miss Hindley did, so she'll be here and he'll be.
That's her case. That's her case. Okay, well then I guess you're done. Have a good weekend.
Okay, thank you.
Do you have an alternate judge? Who's your alternate?
My alternate is Miriam Bobby.
Okay. That means you might have